di-company tse di ikemetseng di kwadise dipego tsa tsone tsa madi re nagano le moitseanape wa molao Simon Bathusi go tsweng ka Armstrongs attorneys. Bathusi ke moitseanape wa molao wa tsa kgwebo ko mo tla tlhalosa mo go tseneletseng ka diphetogo tse dingwe tse di lerilweng ke go ntšhwafadiwa ga molao o ga mmogo le gore di tla ama jang di-company tse di mo tirisong mono. Re sutla ke go dumedise ke go amogela mo Botswana Television.
Thank you for having me.
Alright. A re simolole pisanyo ya rena hela ka go tlhaloganya gore re setse re umakile dingwe tsa diphetogo tse e leng gore di lerilwe ke molao o mošwa. Re tlhalosetse ka boripana ka diphetogo tse dingwe tse o ka reng bagobi ba tshwanetse gore ba di itse.
Okay. I think briefly it's very important just to understand the background there. How did this change come about?
Yeah.
There is an institution or an international body called Financial Action Task Force, which is abbreviated as FATF. They look into laws di amana le anti-money laundering, and what they typically do, they would grey list a country, and basically grey listing a country would mean that that country is deemed to have laws so they are not combating issues of money laundering properly. And we recently had that with Botswana, was listed and it was removed. And what typically happens is that countries improve their laws. They want to go ahead and have laws where they are combating financial crimes such as anti-money laundering. And what we are seeing in this new Companies Act amendment, it is now basically bringing in these concepts. They are usually troublesome. Anti-money laundering. What we are now seeing is that the first and foremost amendment, I would say, the one which says that all companies which were previously not required to have constitutions will now have to do that, basically to have constitutions and submit such constitutions to the Register of Companies, typically known as SIPA. And that means that if you are a company and you are not doing that, you will basically have your company removed from the Register of Companies. And basically that encourages and wants companies to basically come forth and have these constitutions registered. And what we see in the new amendment is that the proposed template constitution, if you like, in some provisions, they require a list of individuals they are controlling such an institution or such a company. So you will end up having a situation where a constitution is registered, and that constitution basically then will then list who are the controlling individuals behind that company. That is the front leading amendment. And then there is another one which relates to that. Companies will now be required to file financial statements. Previously, this was applicable to mostly, let me just say, public companies. It now covers even what we call exempt companies and non-exempt companies.
What are those? Maybe you can make
So exempt companies, in terms of the Companies Act, basically means a company which has assets which are less than 5 million pula in terms of value, and turnover which is less than 10 million in value. So you look at that company and then you say this company is an exempt company such that it is below this threshold of 5 million and 10 million. And then you have what we call a non-exempt company. A non-exempt company, which is a company which is not meeting any of those thresholds. And this would mean a company which is having assets worth maybe 6 million and going up, turnover around 10 million and going up. And these would be companies that they will be required to file financial statements. The Act says there will be a form to be prescribed. Currently, it hasn't been prescribed. We are anticipating that the Register of Companies will come forth and provide such template. One other interesting thing is that non-exempt companies will now be required, over and above just filing financial statements, they will be required to produce auditor's reports. And that is a new introduction, which was typically associated with only public companies. Public companies are companies which are typically owned by 10 or more people or 20 or more people. And most companies which are public companies, you can say that they are typically listed companies. Yes.
Right. Now, before getting into that one, still on this issue, where they should file their financial statement and be transparent with their auditor's report. How would this encourage accountability and transparency within their organizations?
Okay, I think from a perspective of the company as an entity which is operating, I think for purposes of corporate governance, this seems, or this would be something which encourages investors to be interested in dealing with such companies, because first, if you have a constitution, investors take your company very seriously. They look at that company and they can see that there are controls in place as to how things are supposed to be done. And for transparency, you can simply say that we are now able to know who is controlling these companies, and this will obviously allow one of the regulators in Botswana, being FIA, to be able to collaborate with SIPA to be able to get information relating to people controlling entities. So I think from a transparency point of view, this will also be covered and will also assist FIA in its objectives.
Right, ke dumela gore ka molao o mošwa ba ba kadisang di-company ba tlameha gore ba nne le diteseletso jaaka o tlhalositse gore o ka re phetogo e boleng jwa yone ke mo tsamaiseng jwa dikgwebo.
Yes, there is that new requirement here, who we typically call company secretaries. Now the law says that before you appoint someone as a company secretary, that person has to be registered by SIPA. Previously, it was left for the companies to make a determination as to who is competent to be a company secretary, or to basically appoint a company secretary. It only said who cannot be a company secretary, and said you can decide who can be a company secretary, but only determined for public companies, this would be the people allowed. So this, I would say, applies to private companies, which previously it was left for the directors to determine who can be a company secretary. So now the Act basically says you have to pick from anyone approved or registered by SIPA for that person to be a company secretary. Yes.
What could be the challenges that could be brought by these new changes in different companies?
Obviously, this will bring about administrative challenges. They will bring about some expense. To have a constitution, you would ordinarily have to consult a lawyer who will advise you and draft one for you. That would come at a cost, but I presume it will not be a very exorbitant cost, but a very reasonable cost. And again, when you look at the fact that now company secretaries have to be appointed from a pool of registered company secretaries, you will then have these company secretaries now having to go and take an extra step to have themselves registered, and this will be incumbent upon them to do all these things, and obviously on their part this will be an expense. But generally, companies will have to now always ensure that they are ahead of time, ensuring that they comply with these new amendments.
Right, now complying with the new amendments, are companies aware, and what is the expected time for them to have been done with all the proceedings for them to start operating and be held accountable if at all they are not abiding by the new regulations?
Okay, so in terms of this new amendment, in relation to the requirements for companies which previously did not have constitutions, the law says that they have 12 months to have these constitutions prepared and filed with the Register of Companies. So I would say that's a fair amount of time given to business owners to be able to comply. All it takes is for you to walk into a lawyer's office and to get assistance with drafting a constitution, and then to also approach a company secretary who has the requisite registration. I would imagine that SIPA will now get busy with registering a number of businesses which have been assisting people in these services of registering companies and services of providing company secretarial services in general.
Now we are towards the end of the conversation. We are talking about Botswana is talking about appealing to outside those who are doing business outside or foreign direct investment. How would this encourage those who are outside to doing business with companies within our country?
Okay, I think from a business perspective, I would say that this is a very, very welcome development, because when you are dealing with international investors, which we typically do at our establishment, they typically want to see laws which are in line with what the international trends are. And this is moving towards this direction. And you can basically say that it will give investor confidence when they deal with companies from Botswana. And they will trust that we have processes in place which can give their investments some assurance and some basically they'll be safe if they invest in Botswana. So
Right.
I think these are welcome developments.
Most definitely. Now, let's talk to the companies. Maybe as lastly, what is it that they ought to do? You earlier on talked about, getting into, companies by
Yes.
What are the way around this?
I think, like I said, they have 12 months to ensure that they comply. But within that 12 months, you have to make a decision as to whether or when you are going to consult your lawyer to ensure that you, first of all, understand in depth all these amendments that have been introduced. Second of all, then the lawyer will then prepare the necessary documentation, that is the constitution. That is, if you have been operating without one, they will ensure that the constitution which they prepare for you is in line with what this new amendment requires, because it has new expectations as to what should be in that constitution. So these lawyers will advise you and then prepare the necessary constitution for you and assist you with filing this company constitution with SIPA, and then they will also guide you as to who you should consult or who you should use to have as your company secretary.
All right. In 30 seconds, maybe your last words to the companies that are listening to us right now.
I think what we can simply say to the companies is simply that this is a new development, in as much as it's going to encumber your pocket a bit. We should not be discouraged. It is bringing us with the times of the developed countries, and we should embrace this, and we will, with time, get used to these developments, and at the end, the economy will blossom.
Right.
Yes.
Most definitely, and that is how we come to the end of this conversation. Thank you so much for your time.
Thank you.
All right. Wetso re khutla ka tsela ntse jalo ke ne ke buisana hano jalo le re Simon Bathusi go tswang ka Armstrong attorneys e le moitsana pa tsa molao ka molao mo montšha leng gore ke wa mang dikgwebo tsa malahatseng la Botswana gore tshantse go di direng ke boa ka dikgantsana ko ya boraro.
Our world is now marked by rapid technological advances, evolving social dynamics, meaning, therefore, that the challenges that we face are